I want to go back and talk with you about the potential for recreational adult use cannabis as proposed under the governor's budget. Now, the chairman asked you a question with regard to state policy on troopers and employees' recreational use of cannabis, and you indicated the challenge with this drug being federally listed as a Schedule I drug and the use of firearms, which I think begs the question, which is how will the state police handle incidents of individuals who are carrying a concealed weapon, or for that matter, operating motor vehicles while under the use of cannabis?
So I would bifurcate the issue. If they're operating vehicles, we would seek to do DUI enforcement that we currently do with, regardless of the intoxicant, be it a drug or alcohol. In terms of the possession of the firearm, we would seek to enforce the law as written.
So will all of the incidents of a vehicle being operated or an individual carrying a concealed firearm, will they be subject to a THC in the bloodstream test in order for you to handle that case?
I think it would be incident specific, and also as this unfolds, we're going to have to work with the various district attorneys around the Commonwealth to determine what their position is with regard to any of the enforcement on this matter. So, you know, again, until we see the legislation, have a chance to analyze that and have some other discussions about the impact that might have on enforcement, it's probably too early for us to comment in hypothetical about what we might or might not do in terms of blood draws or other enforcement.
So your response indicated that you would work with all of the district attorneys. Do you envision there being varied policies in terms of implementing the law across the different 67 counties?
I think that's possible.
I think that could be potentially very problematic. So we'll continue as we have this conversation to work with you because I think your input will be very important. I think the law needs to be uniformly enforced across the Commonwealth. So Commissioner, if I could switch gears, we've seen a return to law and order at the federal level along our southern border, and illegal immigration across our southern border has slowed dramatically. Last month, it appears that we had the lowest number of arrests at our southern border since May of 2020. However, with that massive influx of individuals over the last 4 years coming illegally over the border, we're still seeing ongoing enforcement across Pennsylvania. We're seeing Immigration, Customs, and Enforcement working with local enforcement partners to remove illegal immigrants, particularly those with criminal records who have outstanding criminal warrants. Are you working with federal partners on these enforcement efforts?
So as we sit here today, we have not been contacted by ICE. We are a collaborative law enforcement agency. If we did receive a request from a fellow state, county, or municipal agency, we would listen to what the request was, and we would try and discern the mission. I would only add that we have a policy in place to deal with undocumented foreign nationals. It's on our forward-facing website, and you know, we would seek to enforce the laws here in Pennsylvania. Obviously, the primacy of immigration enforcement falls to the federal government.
However, if the federal government reached out to you and asked for your assistance, yes or no, would you support them?
If it was a criminal warrant as opposed to an immigration civil or administrative warrant, we have a policy that prohibits the civil or administrative enforcement. On the criminal side, a criminal warrant is a criminal warrant as far as we're concerned. If they needed assistance with a service of a criminal warrant, the answer is yes.
And the policy that you have, is that a result of statute and law, or is that a policy that has been determined by the administration?
So the policy that we have in place predates this administration. AR 714. The interface that we have, we do not seek to identify people in our interactions simply for immigration status. So I would defer to say that on a traffic stop, for example, we have numbers that show 87% of our stops are over in under 15 minutes through the contact data reporting, which shows that the case law of the reason for the traffic stop, once it's been dispensed with, that interaction should end under case law. If there is independent, reasonable suspicion, probable cause, we do not use the FBI, or excuse me, the federal government's database for civil detainers to detain people or identify them specifically. If there is a valid warrant entered into NCIC and we're talking specifics here, the situation, which would be very fact specific, elevated with independent, reasonable suspicion, probable cause, and an arrest was made for whatever violation we see, we would then, as part of the investigation for the offense under state law that we were investigating, we would utilize that database, but not for the sole purpose of deporting or identifying people's citizenship.
However, if a criminal warrant is in
Yes.
the system, you would turn that individual over to Immigration Customs.
We would
and
seek to
Enforcement.
verify the active criminal warrant like we would anywhere else in the Commonwealth or beyond, and we would interface with the law enforcement agency and say, this is who we have, and what would you like to act on the warrant?
I think we would all appreciate that you work collaboratively with all of your law enforcement partners. Thank you. Thank you, Mr. Chairman.